Welcome, everybody, to the world's greatest licensing podcast. This is going to be a great episode today because we're actually talking about licensing issues. And joining me today is Ed Hayburn, our resident licensing expert. He's going to walk us through the news of Fidelity suing Broadcom, which is pretty fantastic. We don't often get to see, Ed, actual litigation over software disputes, especially what Broadcom has done.
I know it is exciting. Most of these cases never make it to the courtroom, and here we are.
So what we want to do is just a little background, folks. Broadcom bought VMware several years ago, I think 2023, and changed all the rules. You all know that. So if you're using VMware, you know that Broadcom has, we've heard, 1,000% price hikes and done kinds of packaging and repackaging in software. And to be fair to Broadcom, what they've done isn't that different than what other companies have done to their own software or when they purchase software. I think the issue here is the software in question is really important and it's really hard to get off of immediately. So I read through the case. Ed and I are going to go through it. And I think it's fascinating if you're in software asset management, if you're in procurement, if you're in IT, if you're in legal, and you are dealing with software contracts or licensing agreements, this is going to resonate with you. So, and it's step one, right, Ed? This is just the complaint.
This is just a complaint. They obviously have a long way to go. Once you file a complaint, then you move into this discovery phase where you have to exchange documents. And that's kind of where these high-tech executives get a little bit uncomfortable because they have to turn over the things that they never had to turn over before. And they also have to sit for depositions. And that can get pretty sticky because there's although when you're in court, you see on TV and you see in a courtroom, only relevant questions can be asked. But in a deposition, it's wide open. You can ask things that may not make it in a courtroom, but it's sure going to make it into a deposition transcript. So this is exciting for tech nerds and legal nerds alike.
Well, and I'd love to be in that deposition. I'd love to hear it. And I know we're going to, walk through the complaint. I don't know if you want to bring that up on the screen,
Sure.
But as we go through this, for those who have a video feed, you'll see there's some areas that are redacted. And I scoured the internets today to find an unredacted version of this. So, why is some of this redacted and will it be unredacted at some point?
I noticed it's odd. It's unusual that a complaint would be redacted. If you were filing medical records with the court or social security numbers, things like that, they have to be redacted. So that was the first thing I noticed, and it was unusual. And it looks like they were
it's the
redacting.
Pricing. It's the pricing.
Yeah, the pricing.
It's
the proprietary.
Exactly. No. I'm sure Fidelity doesn't want people to know what they're paying for the VMware software, and I'm sure VMware doesn't want people to know.
Right.
We gave these guys a sweetheart deal, or we're really screwing them.
Right. It seemed to be like this mutually agreeable thing. Like we'll redact this,
Right.
But it did because when we're recording this, the federal government's dealing with the Epstein emails and all those redactions. So now when people see these redactions, they're going to feel like there's something nefarious to it. But I think you're right. It's just more of a pricing information that both sides are trying to protect.
Hopefully there's no one in this complaint who was on that airplane.
No, I think that these people, although they've gotten themselves into a sticky situation, I don't think it's that kind of situation.
So let's walk through. You got Fidelity suing Broadcom.
But actually, first, obviously, some of our listeners are extremely sophisticated IT people, but there are going to be some people that maybe are in procurement and not as familiar with the IT aspect. I think before we look at the complaint, maybe if you could just briefly explain what VMware is, and I think that'll set the stage on why this litigation is important.
In the context of of this litigation and how most people think of VMware, it's what we call virtualization software. So it enables a company to take one computer or multiple computers and have it look as one computer, or take one computer and have it look as six computers. You create virtual copies of computers. So, for those of you who use a laptop, you might run Windows and Linux on the same laptop. So you've got two virtual desktops on one piece of hardware. So companies will use VMware to maximize the usage of hardware. So in the before virtualization,
Mm.
you would run your software directly on top of the hardware, let's say, and so you were limited, or you would run a piece of software and that hardware would be used 10%. Board virtualization, it allows you to use more of your hardware. So the more you can virtualize, the less your hardware expenses are. So if you can't virtualize, you need a lot more hardware. So that's why people use VMware. So
Mm.
instead of needing 1,000 physical servers, you only need 200 physical servers. So
Mm.
it's a money saving thing. And then obviously, if tomorrow you said, I can't use VMware anymore, you got to buy whole lot of hardware, right? Your systems are going to
Mm.
come crashing down because there isn't enough horsepower behind it to run all that stuff. So it's
And
very,
this
very
isn't
important piece of technology.
an anomaly. This everybody's using VM software, one
Well,
version or the other.
the VMware is the number one virtualization vendor, but there's other vendors out there. I mean, Oracle has their own KVM, and there's other
Right.
vendors that do virtualization. But VMware is the big one, and particularly with enterprises. Big enterprises will use VMware all the time.
Okay. So, in this complaint, Fidelity Technology Group had a contract with Broadcom, and the contract was they were licensing their VM software, and it built into the licensing agreement was a price protection. And it seems to me that it's pretty important for businesses when they're laying out their IT spend to know what they're going to have to pay when they have to renew their software. And the first thing that struck me as interesting about this complaint is it was filed in Massachusetts. Now, both of these companies are Delaware companies, but we often see a lot of this litigation filed in California because the tech companies are all out there. Uh, but there's some interesting things, and they have some ideas that I'd like to talk about it. First part of a complaint, just so that our audience understands. Well, a couple of things. One, this isn't intended to be legal advice, and we're not creating an attorney-client relationship with them. But we are just putting up this complaint and discussing it for educational purposes. And a complaint is where one party files with the court and says that they've been aggrieved and something wrong has happened and they're entitled to some relief. And we'll talk about, as we go through the complaint, we'll talk about the different types of relief. Most people are very familiar with um, like a claim for money damages. We all have that aunt that fell down the stairs and sued somebody, and got a money damage award. That is what's interesting is that's not the important part of this complaint is money damages, but in the complaint is an introduction which sort of just it's not a requirement to be in a complaint, but it sort of sets the stage for the court so the court can see how the parties got to this. The second part of the complaint is the parties, and it's important for the parties to tell the court who they are and where they're located. And in this case, we can see that Fidelity is a Delaware limited liability company, and interestingly, Broadcom is also a Delaware corporation. To me, this was particularly interesting because they could have brought this case not in Massachusetts, where obviously Fidelity, that's their hometown, and I think the fact that it's their hometown is going to be pretty important to this case. but they could have sued in Delaware. And a lot of times corporations like to sue in Delaware because Delaware has a very progressive business court where things get resolved really quick. I mean, things that would normally take years could take months. And they have a very well-developed business court. So attorneys, when they give you an answer, generally they'll refer to the case law, and you don't want an attorney coming back to you and say, well, this court has never heard this issue before, and so we don't know exactly what's going to happen. In Delaware, because there are so many corporations there, and the court's made a very progressive effort to develop the case law, it gives litigants and attorneys alike some sense of comfort, like they've dealt with these issues before.
So
Now,
one
for
of the,
me,
Ed, when we think about why Massachusetts, so VMware used to be its own company, and then Dell bought VMware, and then Dell spun off VMware, and it went over to Broadcom. I think Dell is a Massachusetts-based, or it used to be based in Massachusetts. No, who did Dell buy? They bought EMC. So
okay,
EMC, so that's what it was. I think EMC owned VMware, and then Dell bought EMC, and then but EMC was a Massachusetts-based company, I believe. So all of these agreements, regardless of where the companies are located, they always have provisions for, if I sue you or if you sue me, we're going to go into this particular jurisdiction. So my guess, although I haven't seen the contracts, it's just a guess, is that, based on the timing of this, the contracts that these folks signed specifically stated if there's a dispute, and we'll see they talk about the dispute resolution process. If it goes to court, we've got to go to this jurisdiction, and sometimes these people put Delaware, sometimes they want different states, and then they'll negotiate. Well, let's just do it in Massachusetts because we're all physically in Massachusetts, so we might as well do it here. That's my guess as to why they filed in Mass. It's just that's what the contract.
I don't think that's the case. I mean, we'll find out, and I'd love to talk to the lawyers. I think this is a classic case of Fidelity trying to hometown VM Broadcom and say, okay, you want to argue this? You come to our town, okay? And I'll explain why I think that. One, you're right. There's usually these form selection clauses in these contracts, okay? But as we're going to see, this is a repudiation of a contract. So what we're going to get to is where Fidelity says, well, Broadcom, you've repudiated the contract, which, if true, means that form selection clause is invalid because at least what it seems like, what they're saying in this complaint is the form selection clause isn't going to be valid because you've repudiated the contract. So you can't repudiate a contract and then get the same benefit of it. But here's what I think is happening behind the scenes. When a litigant files this type of case, they have a couple of concerns, and all indications seem to say that Fidelity wants us to stay in Massachusetts. They want a Massachusetts jury. They want a Massachusetts judge. And although judges all try to be fair, there is some sense that if somebody is local, you're sort of going to lean this way. But they go out of their way to make sure that they mention that they have a presence in California. So unlike people, like we only have like one residence. Corporations can have multiple. They can be citizens of multiple places. So they registered their corporation in Delaware. So they're subject to litigating things in Delaware. But they also, their Fidelity's headquarters is in Massachusetts, so they clearly can sue and be sued there. But they also mention that they are in California. And in the complaint, they specifically say that, to the effect that, this can't be removed to federal court under what we call diversity, where you're from one state, I'm from another state, and if I sue you, you can say, "Well, it's not fair to bring it in a state court. This should really be done in a federal court." And that happens all the time. So somebody sues a company in a state court, and the other company says, "Oh, you know what? We're from a different state, so the only thing that's fair is if we bring this to federal court." And there's a huge difference. I'm not exactly sure why, but you can see when you talk to lawyers, there's a huge difference between state court and federal court. One of the differences is the the federal courts will rush you through things, and they'll limit your ability to get discovery. And some state courts will let you go through discovery ad nauseum, whereas a federal court might limit the amount of interrogatories, the written questions. They might limit the amount of depositions. And also, once it's removed to federal court, they can change the venue. So they can remove it to federal court and then transfer it to California. And I'd love to see what the lawyer's mindset was, but my guess is they did everything they could in this complaint to make sure that it wasn't going to get removed to federal court and that it was not going to get transferred to California. And I think when you look at the tech cases coming out of California, especially when they get to the Ninth Circuit Court of Appeals, it just gets really dicey. And I think you just never know where the Ninth Circuit's a huge circuit. There are a lot of judges on the Court of Appeals, and you never know where it's going to. So everything in this case screamed to me that they wanted to stay in Massachusetts, and it looks like they did a good job. And in the complaint, you see they're citing Massachusetts law on jurisdiction and venue to sort of keep them there. So that's the third part of the complaint, is laying out with the court to say, why does this court have jurisdiction? Not every court can hear every type of case.
Right.
And then if the court has jurisdiction, is this particular court proper? And in the complaint, they set out why the Massachusetts court is proper.
Yeah, it's interesting. They didn't. There's nothing in here that says we're filing in Massachusetts because the contract says we have to file in Massachusetts. I guess if the contract did say Massachusetts, they would put that in here. We've agreed that the venue is this court, right? That would be a simple way to do it. I still think the contract said Massachusetts. I'm not conceding you on this one yet, but we'll find out soon enough. Or maybe we won't find out because this will get settled.
Yeah, maybe. It could be. I would be. Yeah, I would absolutely love to know that. Massachusetts is kind of a quirky venue for two tech companies, though. Unless they were both based there, I don't see the upside of it.
Well, just from EMC was a Massachusetts-based company.
Okay.
The templates probably said Massachusetts. That's around the time when they bought this stuff from VMware. So maybe they're just using an old AMC template for this. That's going to be my guess. I'm just thinking it's not something that's heavily negotiated in tech agreements, and it should be when these things come up. It's really important, but we'll see. I mean, it's immaterial here. I mean, I think for us, it's the facts. What did Broadcom do, and when did they do it?
All right. Do you are you comfortable with the facts? Do you want to walk through the facts, and then I'll pick up with the causes of action?
Yeah, let's do that.
Okay.
So I'll share my screen.
Okay.
Share. So I'm going to take over here and let's so now when we look at what actually happened, or what does what does Fidelity claim happened? Unfortunately, some of this stuff is redacted, so we can't see actual dates. But basically, Fidelity bought a license. Sounds like a subscription license, so not a perpetual license. So a subscription. So we can use your products for 2 years. We can use your products for 3 years. And here you can see Fidelity in number 12 says that they've been using the product since 2005. And when you use the product since 2005, they probably bought these perpetual licenses. Maybe Broadcom bought them, and now they moved over to some subscription-based licensing based on what some of the changes that Broadcom made. We can see that in 22 is when Broadcom bought VMware, according to the complaint. Um, and now we have um, Fidelity uh, purchase the VMware products. It doesn't have a total, but that subscription ends in December of 2025. So in a month, this all, and it's interesting because it's a subscription which ends in at the end of the month, at the end of December. So this issue's got to be resolved really fast.
Right.
Uh, from a practical standpoint, on December 23rd, technically the software will still run. It's not like it doesn't sound like it's on VMware's or Broadcom servers. It's not like it gets turned off, but contractually they'll have no rights to use this. So they'll be
Right.
using someone else's IP without a contract. So it's not a compliance issue. Like we sold you 100, you're using 110. This is now a copyright issue. Like you're using our
Right.
stuff, and you have no license to use it at all. Again, unfortunately, a lot of this stuff is blacked out, so we can't see it. I
But
tried to.
wait on that point. We've seen other cases where there's a case. Hopefully, we can get to it in the future with Siemens, where Broadcom sued Siemens, and they were looking for an engorgement of profits. So if what you're saying is right, and I know it is, that they could have theoretically still continued to use it because it wasn't on their server, it would have, a cause of action could have arisen where Broadcom could have then said, okay, but all the profits that you made from using our software, we're entitled to, which could have been in the millions and millions.
Well, and I think that's exactly why Fidelity is doing this now. They're not waiting
Right.
for Broadcom to
Right.
have that opportunity. Um, so then we've got the acquisition of VMware by Broadcom, and then in December 23, Broadcom. Everyone listening, if you're in the licensing space and you deal with these issues, Broadcom made tons of changes to how VMware licensed software. And without getting into the particulars, because they are listed here, if you want to copy the complaint, it'll be on our website. You can find it. They basically took these little pieces, or not little, these component pieces, and they put them in big bundles. So used to cost $1 for this thing over here, but now you got to buy 10 products and it costs $10. Even though you're not using 9 of the 10
Mm.
products, fundamentally that is what Broadcom has been doing. So creating these big bundles out of these little pieces and not allowing people to buy the pieces anymore. And I think according to VMware, I would think the price went up, right? If the price went down, Fidelity would have just bought the bundle, but obviously the
Right.
price goes way up. So back in March of this year, so the contract ends in December of this year. In March of this year, Fidelity said, "Hey, we want to exercise our contractual right to renew the subscription." So for another year, another 2 years, another 3 years, whatever the contract said, according to Fidelity, they had a right to do it. And a month later, in April, Broadcom came back and said, "Nope, we are not going to allow you to renew it. You have to buy the
Right.
bundle."
So what you're talking about is price protection, and you've been, I mean, you were with Oracle for 15 years, and now you've been running your own business for 15 years. You're the person that was negotiating these contracts on both sides now. How important is price protection to a business like yours or business like Fidelity?
Well, this goes beyond price protection. Price protection is just, I bought a license to use the product and it's perpetual. And now, or I want to buy more of that license. I want to buy, I bought 10 and I want to buy 10 more. This is literally a right to renew or a right to continue using that. So it's not only price protection, but it's usage protection, right? If they don't get this, they can't use the stuff. They can't use the software because it's a term license, right? You get a subscription for Netflix and you pay for a year, in 13 months, you have no right to use it unless you renew your subscription. So that's what we're talking about here. It's actually renewing, it's extending your rights to use the software. So it's not just about, hey, this is going to cost us a little bit more. Like this could cost us 10 times more, 20 times more. And what we've seen, and I don't know the particulars here because I don't know what's in the contract. For me, it always goes back to the contract. What did the contract say? Did it say you may renew this product if we continue to sell that product? That's something Oracle did all the time. Like we would have a price hold here's the price that you can buy this product, assuming we still sell that product in 3 years,
Right.
right? And then Oracle always packaged software up and unbundled it and bundled it and put it in different things. And, what was, this product is now that product, and they changed the name. So this, what Broadcom is alleged to have done here is not unusual. Like companies do this. They take a product and they bundle it in with something else. You had price protection, or you had the right to renew it, but typically those agreements say, as long as we sell this to other customers, we will sell it to you at this price.
Right.
Now, in this case, I don't know what the contract says. Also, there has been some 20-year relationship where you're relying on the other party to act a certain way, and now all of a sudden Broadcom is alleged to have changed all that. So,
Right.
you know good on Fidelity, right? Because this thing ends in December. They went to Broadcom in March, which is, so they did something right. They didn't go to Broadcom in November, right? They went
Right.
well in advance. And my guess is the contract said you've got this provision, and it talks about it in this complaint. If there's a dispute, the dispute resolution clause, we have to go to arbitration, we have to do this, the executives will meet once for 6 months, and if all of that fails, then we can sue each other, right? so
Right.
so that's what they're alleging here, is that Broadcom said no. We tried to negotiate. They absolutely refused to honor a contractual right to renew for the price, and it says price protection period.
For the
So
price. For the
yeah,
price.
and Broadcom's like, nope, nope, no, 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 and the 6 months ran out, which brings us to today, the dispute resolution provision, and they got section numbers and things, and they said, hey, we've done everything we could. Like we went in early, it's in our contract. We tried to negotiate good in good faith over the last 6 months. Time is of the essence now. This thing expired,
Mhm.
and we're going to be out of business if we don't get some resolution here. And Broadcom said, absolutely not. You pay us this money, or you can't use our stuff anymore. So it's a price issue, right? And so I don't know what the contract says. I don't know if it says, I'm just thinking, if this gets into be a contract dispute, um, and provision, and you're sort of arguing contract interpretation. Did they have a right to renew it under any circumstances? Did they have a right to renew it under a certain set of circumstances which don't exist anymore? So, Broadcom is pretty tough to deal with. We've
Right.
represented clients in audits against Broadcom, so it's like Oracle on steroids these days.
Right.
But I can't give you an answer like, are they doing something wrong here? Did they violate the contract? Is Fidelity entitled to this? Obviously, that's going to go. My guess is it'll settle. There won't be a jury. There won't be a judge making a verdict in December, but who knows? Um, so that's where we are. Contract was signed. Fidelity alleges Broadcom won't renew it, even though they're contractually obligated to do it. Broadcom has threatened them and said, if you don't give us this amount of money, you're not allowed to use our stuff anymore. Fidelity says, that basically puts us out of business. We have no other choice but to sue you.
Hmm. When I was reading through this, I was thinking about how many of our clients have always come to us and said, we want to be good partners with the software vendors. We want to be fair. We understand that their software is valuable, and we're not looking to take advantage of anybody. We just want to be fair, and we're willing to pay for what we owe, but we don't want to get exploited. But then you see the tech vendors that are clearly who have the upper hand that are exploiting these agreements. At least that's what it seems from this complaint. But I thought it was interesting because you have, you know, decent people doing, like you said, they did everything that they could. They went to arbitration. They were only looking to have the clause that was negotiated on the price renewed. They weren't looking to pay less. They were looking to pay for what they had agreed upon. And from the complaint, it looks like Broadcom is trying to take advantage of them because it would cripple their business. Like you said, what are the? I mean, how are they going to go out and buy all the hardware to now replicate what they're doing with the VM software?
Yeah, or move on to a VMware competitor, something like that. Yeah, and
How
he even
we
said it's 18 to 24 months to do that.
right? That seems like a Herculean task to be able to switch midstream, and it must. I'm sure it interrupts their business process in that 18 to 24 months. It's not something that can be slowly rolled out.
Well, yes, it's a total. It's millions and the cost of the
Hmm.
software from VMware Broadcom will pale in comparison to
Right,
a migration cost, right? So
right,
at the end of the day, my guess is at the end of the day, let's say this a judge hears the case and on December 18th makes a ruling in Broadcom's favor and says to Fidelity, you you either pay up or you stop using the software. Of course, Fidelity will appeal and try to get injunctive and try to get a stay and extension and do all that. But let's assume all of the path in the goes up to the Supreme Court before the December end date, and they rule in broad. So everybody rules in Broadcom's favor. Um, of course, Fidelity is going to pay the money. They're
right,
going to pay whatever Broadcom said they're going to pay, right? And
right.
and obviously Broadcom would then be obligated to renew it, and you can't punish these guys or charge them more than list fee or anything like that. But they're in a tough spot, and I've been in many disputes. Our clients have disputes with various vendors, not just Oracle. And for it to go to court is big. I mean,
Right.
uh, something happened here. There's more than what's in here. I can't imagine that Broadcom believes they're violating the contract. I think they have an interpretation in their heads that they believe, and the one that I think of all the time is that the contract says you can renew at this price, provided that's still something on our price list. And now they're coming and saying that's actually not on our price list anymore. And you knew that
Mm.
back in 2023. You could have started a migration back in 2023 if you didn't want to pay these new prices. But who knows? These
That's
companies are talking all the time, right? You talked about discovery. There's going to be 3 years of discovery between salespeople and executives and IT, and like all of that is going to come out potentially in this. Um, also,
that's interesting. I obviously having been in the industry for 30 years, all these nuances and the different positions that these companies take. Looking at it from the outside in, it seemed like a law and economics problem. And it's like, if you remember your professor saying, if you're in an apartment and you're paying $2,000 a month, and there's an apartment across the street and you only have to pay $1,900, well, the free market would say, well, sure, you'd move across the street to the apartment and pay $100 less. But the cost and the aggravation of moving across the street is just not worth it. So you'll pay the extra $100. So it's never really a free market in these situations because of that law and economics issue. That's how I saw it. But I mean, I'm sure you're right.
no, no, and both can be true. And the switching costs, like I said, the 18 to 24-month program to move off of VMware would cost so much more than just
Mhm.
paying Broadcom, right? I have to imagine that is,
Right.
that's the economics here. But what Broadcom wants is so much more than what Fidelity thinks they should be paying.
Right.
I'm guessing here. Fidelity's like, man, we agree. We have a contract. We signed this. You guys have been working with us for 20 years. Why are you screwing me now? Like, that's
Right.
ridiculous. So
Right.
someone at Fidelity had to say, screw these guys. This is probably not the first issue that's come up. There's been some bad blood here, and we can't resolve it. But the
Yeah.
numbers have to be like, I don't know. Fidelity thinks they should be paying, $4 million a year, and Broadcom wants $50 million a year. I mean, there's
Yeah.
got to be a 10x increase. I would
Yeah.
imagine, based on what I've read from other vendors and seen from our clients. There's got to be some huge delta here between what Fidelity thinks they're getting, and what Broadcom thinks they should be getting.
I agree. If it was just $1 million issue, I bet you Fidelity would have bit the bullet and just paid it begrudgingly. But you
I've,
know,
I've seen customers write $100 million checks to tech vendors to make them go away. Like, you talk
that's
about the switching
amazing.
costs, right? You don't
Yeah.
know. Write that to me. Give me half of that.
Right.
We'll fix this.
Right. Yeah.
But it is sometimes you just, because listen, Fidelity's business is not virtualizing databases and software. Fidelity's business is providing advice and managing finances and doing things like that. This is a distraction for them. This is a big
Right.
distraction. Another interesting thing when I went through this is Fidelity says, when they're going to the court, saying, we want you to force Broadcom to renew this thing. And um, if you if we lose, the cost for us is unbelievable. But if they lose, there's no cost to them. There's no damage to Broadcom. It's just, we're going to continue giving you that amount that we gave you before. Like, there's nothing Broadcom has to do differently if they lose this case, other than send the invoice over to Fidelity.
Yeah. Let me pull up my screen and let's talk about the causes of action. Okay. So the next part of the complaint, you went through the facts and did a
We
great
we gotta
job.
we gotta find who, if anybody has this unredacted version of this, they can send our way. Please send it. I want to read that contract. I'm dying here.
Well, right. At the end of the contract are attachments, and obviously they're under seal. But if you get a judge who's going to threaten, say, you know what, I think that we have to unredact this and let this be out in the public, and that might make Broadcom, come to the table. I don't know. I don't know who has more of a vested interest in keeping the contract under seal. I understand, you made the point that Fidelity may not want anybody knowing that they got a sweetheart deal, but I have to think that Broadcom definitely doesn't want that contract out.
Definitely, I would say, maybe not. I don't know the particulars of this one, but in general, the risk is on the vendor. Like, if Fidelity did get a sweetheart deal, and now it's in the public domain, everyone is negotiating with Broadcom. Is like, hey, I didn't get that deal. Like, I've given you more money than them. Why are you screwing me?
Right,
It becomes a problem, not an insurmountable problem, especially when it comes to software. You're discounting for software it's flexible. There's an unlimited flexibility. It's not like you're selling a car where there's a cost.
right,
You're giving access to someone to download bits and bytes from your website. So if they
right.
sell it for $1 or sell it for $100, at the end of the day, there's no difference in cost to Broadcom. It's just an interesting market.
It's
There's
a,
development cost and everything, but it's just, you can have a 99% discount or a 1% discount for
right.
software.
Yeah, that is interesting. That's a great point. And you would think that that would make software less expensive, but clearly the trend is software is getting more and more expensive. You know,
Well,
but
in this case, it sure did. That's right. Again, if
yeah,
if if VM if Broadcom bundled everything together and went to Fidelity and said, "Hey, we're charging you the same amount but you get all this extra stuff," Fidelity would not be suing Broadcom, right? The only
right,
reason they're suing is because the price is right. The price
right,
is not right. Sorry.
right. So the next section of the complaint is causes of action, and that's where the plaintiff, which is Fidelity, the one bringing the lawsuit, says, this is what was done wrong, and this is why I'm entitled to relief. And the first count is pretty straightforward: breach of contract. So they're saying we had a contract with Fidelity had a contract with Broadcom for licensing of their VM software, and embedded in that licensing agreement was this price protection that they could renew it at a certain price.
Yep.
The funny thing, as we're recording this, the Major League Baseball is going through all the free agency where players are opting out of contracts and giving up 2 years of a contract and a new one. And it's interesting because that's kind of not how these contracts are written. It's not like you have an option. This contract is, well, I guess maybe it is in a way, right? I guess if we looked at the contract, they had an option to renew, but I guess the contract didn't say that Fidelity was compelled to renew, right?
My guess is you're exactly right. There was an option to renew or extend certain grants, license access, things like that, ongoing maintenance that Broadcom and Fidelity exercised the option, and Broadcom said, "We're not recognizing that. We're not recognizing
Right,
your acceptance, right?"
right.
Like a player, it's like, "Okay, I'm going to do the third year. You have to pay me," and the team says, "Nah, I know what the contract says, but we're not going to do the third year."
Right, right. So in this, this is probably the most straightforward cause of action is a breach of contract,
And
and
this
in
is
a,
where
in a
I'm always interested. 'Cause I read this, and I dabble in looking at these complaints once in a while. So I know breach of contract. Like I'm reading this, going, okay, this is a breach of contract thing. I know
Mhm.
it, but I love some of the other claims. Like, and you're going to get into that in a second because it's like, it's not just breach of contract, but it's also you're being a dick.
Right,
You need to
right.
stop doing
But
that.
well, what's going to happen down the line is one of the things that's baked into the law is if you are the maker of the contract, that contract will be construed against you.
Yep.
So when Broadcom comes to court, they can't say, well, this clause is a little bit vague and we think that, you should interpret it this way. The court's going to say to them, well, you made the contract and you made it vague. So we're going to construe the contract against you. But this is the most straightforward claim where Fidelity says that they had a right to, right here, paragraph 41. They exercised their right to renew their subscription to the software under the enterprise order, and this is where they're saying that Broadcom refused to honor that portion of the contract. And again, so the people listening, just so that it's fair, obviously, it seems like we're beating up on Broadcom. This is just Fidelity's. This is Fidelity's complaint. Broadcom will have an opportunity to answer this complaint, and they may bring some facts in their answer that may shed a little bit more light on this.
When
The
if you just go, we talk about that section 4. They said it's breach of contract. We had the right to renew. There's a lot of sections that are redacted here. So I would have expected to see that clause right here to say the clause says this. Like it's pretty clear. So maybe there is some ambiguity here. And you were talking about construing the contract against the drafter in some of these large enterprise deals. um, I highly doubt it happened here because EMC and VMware and Broadcom are all big companies, one bigger than the next. Um, Sometimes the purchaser gives their contract, and you sort of negotiate off that one. Other times, there's such huge companies that they're okay. We started with that contract, but you've negotiated it basically to the point where it's almost a custom agreement.
right.
So some of the ambiguity, and again, this will go in if this keeps going. Like there's the clause in the contract that says you can renew, but was that the original version? Were there previous versions
Mhm.
of that? Did Fidelity change it? I've seen clients before they were our clients make changes to vendors' contracts that were not in the client's best interest. I'm like, in my head, I'm going, why did you do that? Like that was
Right.
terribly. So I'm wondering here again. I'd love for this to play through the courts. I would go to Massachusetts and sit in a court and watch this so that I could report on it. Again, I doubt that's going to happen, but there is a provision there, and I would have expected to see it right here. In other uh, complaints that I've read through, and some of them we've blogged about, and I've done videos on, they put the language right in here. So I'm wondering why that's not. Sometimes it's what's not in the complaint that you have to think about. Like it was the same thing with the governing. Why is it in Massachusetts? Like if the contract said we have to sue in Massachusetts, I would have guessed, you know, that it would say that here, but who knows?
Yeah,
There's a
I
bigger story here, Ed.
there is. I think your instincts are right. I think that there's going to be litigation over whether the right to renew was ambiguous, because Broadcom's. I mean, they're a sophisticated company. They're not. I think there are a couple of things going on. One, I mean, you laid out that there were acquisitions. So the people that are allegedly repudiating these contracts probably aren't the same people that were involved in negotiating and negotiating the terms of it. So I think that if they actually did put the clause that they're referring to, they didn't even put, because they attach a copy of the documents,
Oh,
although
they
we don't
did,
have them.
but we can't see it. You're right.
We
So
can't see it, right?
maybe all this pontificating I'm doing,
No, no,
the
I
actual
think you're right.
complaint has the document.
Right, but which is important because that then all of that is before the court. But what struck me, I think that was a good catch that you said, well, normally you would just cut and paste the language of the clause of the contract, but they don't even cite. I would have expected them to say, under paragraph 93 on page 55 under section blah blah blah, it gives us the right. They don't even do that. So I think that we're probably going to find out that you're right, that there's a lot of ambiguity, and that there were so many revisions that kind of made it more vague. I don't think it's going to help Broadcom very much, but
Let me
you
ask
know,
you, sort of thinking about this, and we might not have the answer to this, but this is not the first time I've heard of Broadcom being aggressive with their customers. And it's obviously
mm,
a good piece of litigation that hasn't been brought forward before this time. If you're in a similar situation as the situation Fidelity says they're in, like, so you're another company, come ABC, Acme Dynamite Company, and you're using VMware, and um, Broadcom is doing the same thing to you that they're allegedly doing to Fidelity. You're probably watching this. Like, can you join
oh
this
my god, yeah.
case? Can you join this, or do you have to do separate? You have to. I'm going to pile on. Like they're waiting for something to happen here so they can jump on Broadcom too.
Right. I don't. My guess is that the court wouldn't let them join because they're not involved in this particular contract. But along that line, there's the concept of issue preclusion, and this issue preclusion is where a court decides an issue, and if these contracts, I assume that they're standard, and I know that you said there were probably a lot of revisions, but if this Massachusetts court tells Broadcom, this clause gives your clients the right to renew at the price stated, and the court makes that determination, that is then going to be binding on Broadcom and all of its other customers. So if Broadcom tries to do this to another company, they're going to say, well, wait a minute, you just argued this issue and the court decided that you can't do that. So that, and to me, and I really haven't seen anybody write on it, and I wish that they would. That is what makes these companies settle, because if Broadcom settles this case, then they could litigate this over and over and over with every single one. But if a court decides that Broadcom can't do that under this contract, they're stuck, and every time they do it, what their clients are going to do is they're going to file suit. They're going to file for, and we'll get to declaratory judgment, but they're going to file a declaratory judgment. They're going to say a Massachusetts court has reviewed this contract. It's identical to our contract. And Broadcom had an opportunity to litigate this, and they lost. And now they're bound by that interpretation on every other one of these related contracts. I think issue preclusion in law school is perhaps one of the most boring issues ever, but here it's key.
And also, though, if you are a customer who's in a similar situation to Fidelity, and you buckled and just wrote Broadcom a check in August of this year because they were threatening you, shutting us off, and you're like, I'm not going to sue, but I'll just write the check. Do you have I guess you can then go back to, whoa, you guys screwed me. I want my money back. Like, I want the old deal.
I mean, you're saying legally, or you're just saying as a practical matter?
Well, I mean, listen, every state's going to be a little different, and the contracts you'll never have a perfect match. There'll be some apples and oranges to each one, but I know when Mars sued Oracle over a virtualization issue, that was settled. Right. We were, we're not counsel. We don't represent Mars, but we were supporting their attorneys, and that was settled. And I know after the fact, when that thing sort of went away, Oracle's behavior changed. So they didn't lose, they didn't win, they didn't lose. It was settled. Nobody knows what happens. I mean, we know what happened, but it's not publicly known, what happened, and but behavior changed. So I'm wondering, regardless of even if Broadcom settles this, it'd be interesting to see, in 3 months, did they settle it and change their ways, or did they settle it and just continue to do the same thing? Because they've got 1,000 customers. One of them sued. That means 999 did something else, right? So, so the cost of the lawsuit is going to be de minimis for Broadcom. But you're right. Losing the lawsuit could be huge because now it's all of the future clients as well that they can't force into the bundle.
Yeah, I remember.
What else do we got? What else do we got, Ed, in terms of causes of action?
Okay, so the second one is probably the more interesting part. It's anticipatory repudiation, and that's when the contract isn't technically breached yet because it hasn't expired, right?
You're
so they're still under a contract.
You're going to screw me next month, and before you screw me, I need this court to get involved so I don't get screwed.
Right.
You haven't screwed me yet, but you're about to screw me.
It's like when you have a Tinder date and you think you're going to get ghosted, and you say, "Well, I know you're going to ghost me, so I'm ghosting you first." But this essentially is when, and there's always in these anticipatory repudiation cases, there's always language where that they're not going to honor a portion of the contract. And
according to Fidelity, Broadcom is pretty friggin' clear. Like, no. You can't use this stuff. Like, there must be emails and communications that says, no, this goes away and you'll have no rights to the software after December 20th, December whatever, and you're going to be screwed.
Right.
I would imagine the salespeople at Broadcom, just guessing, have made some, before it got into the litigation mindset, when it was in the sales mindset, there's probably a lot of communications that went back and forth between the two companies that both sides aren't going to want out there in the public domain as part of a deposition.
Right. No, I agree. So the count to anticipatory repudiation gives a party an opportunity to come to court without having to wait. Normally, you have to wait until you have a cause of action, right? So if it's a breach of contract, you have to wait until they breach the contract. But they just courts know that that's not really helpful to the business cycle. If you know somebody's going to breach the contract and you want an answer, you can get the court to decide it. And I thought that was kind of interesting.
I think people in sort of outside of the sort of legal world, from a criminal perspective, cops have to wait for a crime before they can arrest you for a crime. I think you're going to commit a crime in a month, so we're going to arrest you now because, so this is it gives people the ability to anticipate. Like, I mean, it says anticipatory. It gives them the ability to do something before the harm has been incurred.
Right. Right. And because here in this particular case, we're going to see the harm could be devastating. So why wait for that? This clause, breach of implied covenant of good faith and fair dealing. And, this is the type of clause, if you're a law school student, you think, wow, this is great. This is what contracts are all about. We all have to be fair and we have to deal in good faith. And then it is that there's nothing in these contracts that are ever fair and good faith and fair dealing. I mean, we see it time and time again. It's just really backstabbing. But they have to put it in. They have to put it in the complaint because parties. You're not supposed to be able to trick another party. Okay, you're not supposed to be able to say, "Okay, wink, wink, sign this contract, and you can renew for this price," knowing that you're not going to renew it. I just don't. I just haven't really seen any evidence that um, parties are winning on this cause of action alone. I think the breach
It's
of
a throw-in
contract.
clause, right?
Yeah, it is a throw-in
If there
clause.
wasn't the breach of contract clause, everything else goes away. From what
Right,
I've seen, right? So
right,
there's a basic human understanding that we will treat each other. I don't want to ethically, at least. We're not going to
right,
lie, cheat, and steal. And so, if you read these agreements, they don't say that. It doesn't say,
right,
we both agree that we will not lie. That we will not cheat each other. It's like,
right,
it's just you. That is how you do business. Like, there's got to be some bedrock of civility,
right,
normalcy to doing business. And so they'll throw these things in. It's always the third or fourth or 20th count in these complaints that I've seen.
right. I don't think that's the heart of it. I don't see it. Um, Here, the count four is declaratory judgment. So this is really the heart of the matter because what they're doing is they're throwing it before the court and they're asking a court they're saying essentially, here's the agreement. We don't have it, but the court does, and they're saying you can look at it and you can make a decision and then you can come out in our favor. What's interesting about declaratory judgment is sometimes the judges can just look at it because it's a contract case. Sometimes the judges can look at it and say, well, the contract says this. And, he or she is going to say, well, I decide for the plaintiff or I decide for the defendant, and then just make that decision. But often you see judges say, well, there's a little bit more of a nuance to this. Let me take depositions about what was happening in the background to sort of supplement it. But in other times, you'll see a declaratory judgment case. A lot of times they're filed separately, but you'll just see a judge have oral argument and have the case. Parties will brief the law on it, and the judge will just make the decision. I suspect that this is going to go through some discovery, though.
Well, and
Um,
like I think you said in the beginning, this is Act One, right? So they're not going
right,
to get declaratory judgment before Broadcom responds, right? At the very least, there will be a response. I shouldn't say that. This will be withdrawn because they settle, or Broadcom will respond, and then they'll settle, or then there'll be depositions, but something has to happen by the end of December. Like this,
right,
if a judge does nothing and says, I'll hear the case in January. Well, Broadcom's going to turn off the access rights for VMware, right? And then if I'm
right,
Broadcom, now I have a claim of action against against Fidelity. So, this from one of the exciting things here is it's got to move fast. So we're going to know in
right.
December what happened with this thing,
Yeah,
and
it's
we
just a
might
matter.
just know that it's settled.
Right. Well, it's almost like Netflix is going to pick it up, and it's going to be a 8-part series. But so the next section is a prayer for relief, and what you're referring to is they ask for a preliminary injunction because they're running out of time. They have a month to be able to work out this issue, and I think saying that the court would hear it in January would be generous. This is not going to be. The court's probably not even going to entertain any motions well into next year. So under subsection E, they ask for a preliminary injunction, and that's essentially where they're telling the court, if you don't stop Broadcom from terminating our license, shutting off our software, there's going to be irreparable harm.
Yep.
Okay. And a lot of times that's what gets sticky. It's because, losing money in and of itself isn't irreparable harm. That's something where, even if it's $1 billion, if they say, well, to the court, we want injunctive relief because if we're right and you don't give injunctive relief, we could lose $1 billion. The court's going to say, well, okay, but then we could just make Broadcom pay you $1 billion. So you're not entitled to injunctive relief. So, so this is where Fidelity makes out a case that they need the injunctive relief because the harm's going to be worse than just a money damage.
I'm just not that the judge needs some advice here. Whoever's hearing this case, I would give injunctive relief.
I think you're right, because if nothing else, it's the status quo, and I mean, courts love the status quo. I mean, how many times do you see in every other than maybe criminal, but like in family court cases, in business cases, in civil cases, it's like, well, let's just keep what we're doing now until we can figure out what the answer is.
And I think Fidelity gets into this a little bit. Even if it's a 6-month extension or something like that, Broadcom's getting more money. Like they're getting what they
Right.
would have gotten, under the agreement potentially. So, or it's, just give them this amount of money, but if you lose, then you have to give them the rest. Like so, yeah. But something will like it's not like this is going to be silent by December. Like something has to happen, injunctive relief, or
Right.
someone's getting screwed big time if
Right.
the court doesn't do anything. Like if they just say thank you Broadcom for your,
Yeah.
they file a response to the complaint next week, the day before Thanksgiving, and the judge says I want to have a hearing on January 4th. Like
Right.
that's really bad for Fidelity. Uh,
They would be panicking. Well, I don't know what the dollar amount in question is, but I think that they would end up if denying them their relief is as valuable as they say it is. I think they would have to pay it.
Can you
But
appeal
then,
that? If a judge says we're not going to do this until January, can you go to the appellate court and say, "Hey, this guy made a mistake. I really need injunctive relief"?
um, but yeah, I assume so. We're in a weird time, right? So we're seeing all the litigation with the president, and the president gets this deference that if he doesn't get what he wants in a lower court, he almost immediately gets an appeal. But the rest of us, we don't get those rights. You have usually you have an appeal, and every state is completely different, and the federal system's different. But usually you have an appeal at the end of the case. And then in rare circumstances, you have an appeal based on an order inside a case. But the courts generally don't like piecemeal litigation. They would much rather you say, "We'll deal with the whole case, and then we'll straighten out whether or not there were errors."
Mhm.
But I tend to think you hit on it. You're right. That's something this serious, where if a court denied injunctive relief, that would be enough for an emergent order for an appellate division to agree. But I think it would be insane for a trial court judge to not say, to not issue an injunction, just keep the status quo, at least get us through the Christmas holidays, right?
Right.
And then sort this out. And so many courts just love to punt issues, and especially in state court and in federal court, they're putting pressure on you. Certain courts, like in Virginia, they have the rocket docket, and they want to get this settled. And even in some of the federal criminal cases, like James Comey got arraigned, and they were saying, "Well, we're going to set a January trial date." And it's like the guy doesn't even have the charges yet, but they're pushing it so fast. But I think that the court's going to issue injunctive relief. Um, then. The other thing that struck me that was interesting is the award of damages, right? Because we're really talking about money. So your first instinct is, well, how much money are they asking that Broadcom pay? But it's not about money, right? So they just say, they're asking for an award of damages if proves at trial to the extent damages are available in addition to
Right.
injunctive relief. So they're not. This isn't a damages case. This isn't where Broadcom turned off their software. I don't know if that's possible, or prevented them from using it, and then they lost millions or billions of dollars. They
No, I
really
think
want
that,
the injunctive.
yeah, that's what we talked about earlier. My guess is it's on-prem software, so they have access to the software. So, again, I run, I remember we used to have CDs and used to run like things
Right,
right on your computer. Like you have the
right,
software, you have the code. There's
right.
nothing that Broadcom can do to sort of remotely turn it off. But that code is updated all the time. You're getting patches, you're getting updates.
Mm,
Plus, again, it's a subscription, not a perpetual license, so it runs out. It runs out in December. So even though you have the CD in your hand or you have the code on your computers and your servers, you still have no rights to use it. Just because you have it doesn't mean you can use it. So that's where the damage is for Fidelity. If they continue using this after the subscription expires, that's when Broadcom can jump in and say, "Whoa, whoa, whoa, we want all your profits now,"
right,
right? That sort
right.
of thing. So,
Yeah.
um, there's a lot here for for again, software asset management, for procurement, for obviously for
Mhm.
attorneys that are watching this. We're following it closely because it's right in our wheelhouse, and we've seen customers sort of heavy-handed tactics by Broadcom and others. Again, it's and I don't even want to beat up on Broadcom. Again, I don't know what that contract says. I don't know,
Right,
what Fidelity agreed to. I don't know what they negotiated. I don't know the language that the sales team at Broadcom was using
right,
that the technical team and the procurement team at Fidelity. This is for me. This boils down to the facts because I do like you said. I came back from Oracle and we when I put my Oracle hat on, we bundled and unbundled software all the time. It just
right,
made business sense. There used to be partitioning option, used to be an extra cost feature of the database, and then it became part of the database, and then other products that were in the database came out of the database, and they
yeah,
did. Oracle did so many acquisitions, and they changed PeopleSoft and Siebel and
mm,
Hyperion and all the licensing changed, and we ripped out all those old agreements and put in new agreements, right? So on the face of it, although it might be tough, I can't say, oh, Broadcom's evil here. Broadcom did anything wrong. I
right,
just don't know what the facts are here. All those redacted parts and the missing clause, missing contracts. That's what we really need. Like, I think once we have that, then we'll have, here's really what, shed a lot more light on, what the parties can and can't do. But regardless, it's huge for Fidelity because if they can't use the software, they're shut down.
right.
Not literally shut down, but it's going to be a big problem for them. And if Broadcom loses, uh, it's going to be a big problem for them because they generate a lot of revenue from what they're
Right.
doing,
Let
allegedly
me ask you
doing.
this.
Yeah.
Would you be willing to
Yes.
open up this
Yes.
mic and
Yes.
invite Broadcom and its lawyers onto the world's greatest licensing podcast to make their case to the public directly and explain why it is that Fidelity is wrong? Would you
I,
be willing? Would you let them come on your podcast?
Listen, I would let absolutely open invitation, and I'll even extend that to Fidelity. We actually reached out
Okay.
to one of the Fidelity attorneys who filed this. I haven't heard back from them. So as of recording this broadcast, there's been no response from the Fidelity attorneys. But absolutely, I'd love, and maybe we do that sort of after the dust settles. Like they probably don't want
Hmm.
to come on now while it's in litigation. Or here's
Right.
another idea: let's not have this litigated in front of a jury. They can come here
Mm.
on both sides. and I will litigate this. And
Let you decide. I mean,
I will
you
decide.
you you've literally spent 15 years on each side. There could be nobody that has a better perspective than you.
Like I said, I can't even beat up on Broadcom here, right? I lived that world for years and years, and I can't beat up on Fidelity because they, like I really want to know. Like, when we do audits, I say the vendor when they audit you, they are not looking for the ultimate truth. They're just looking for leverage. And so Broadcom has a
Right.
lot of leverage here, right? And the only leverage that Fidelity had is suing or paying, right? You could pay or you could sue, and they chose to sue. Okay, but I would sit down and want to find the ultimate truth here, and with Fidelity and Broadcom. But listen, even if Fidelity wins and the judge says, you know what, Broadcom, you have to renew that agreement. If I'm Broadcom, for next thing I'm doing is I'm that's your last price protection. So good luck on your 24-month journey moving away from us. Now you're going to spend a
Mm,
shitload of money. So even if Broadcom were to lose, sort of tactically or cave to Fidelity this one time, it's still their software and it's still a subscription, and they're going to have that inflection point 2 or 3 years down the road anyway. So Fidelity's got some big decisions to make. If I'm Fidelity, I'm not relying on this stuff anymore. If I'm suing you, am I really going to continue to put my faith that the next renewal you're going to not do the same thing to me?
mm,
I need an escape plan, and that's good business practice is not only you have good contracts, but you have you have an escape path. It
right.
usually takes one renewal, like even at Palisade. If we were to stop using a CRM tool that we have or something, it would take us a year to move off of that thing, and
Right.
we'd have to license the new one and the old one at the same time, and
Right.
it just becomes a mess. But there couldn't be a case more on point in terms of what we see and do. So Ed, thank you so much for
Oh, thank
leading the
you.
discussion, and we're going to do the next one when we see the response from the FU response on
Right.
Broadcom. Because that's what I'd be writing right now.
Right. But I see they generally have like a month to 45 days, but I think it's going to ruin some people's Christmas while they're working on this answer.
Well, that's interesting. So if this, I don't remember when it was filed. Let's say it was filed on November 15th. Just I know it wasn't, but
Mhm.
and you have 45 days to respond. If
Right.
I'm Broadcom, I'm taking 45 days to respond because
But
it's going to be after the renewal.
I think the judge is going to issue, he or she is going to issue the issue the injunction first.
Right. So
Right.
what do you think is going to happen next? Is Broadcom going to respond, or is this going to be settled?
I think that I don't think either parties have gotten their pound of flesh, and then also the lawyers lawyers are going to lawyer, so they're going to be like, oh no, we can't, don't
Right.
settle, we haven't billed enough hours,
Lawyers would,
and they're going to want the depositions, even though it may not even be relevant in a contract case, to put a CEO or somebody that was in your position. Did you ever have to testify in a deposition for Oracle?
I never testified in a deposition for Oracle, but I have testified as an expert witness in
Mm,
cases involving Oracle licensing,
okay.
and not with Oracle as parties. There were other parties to these cases, so it's just kind of interesting. It's implementers and technologists and Oracle customers and partners
Hmm.
and things like that. So, yeah, it's nerve wracking,
Yeah.
and it wasn't even a deposition. It was testimony, put your hand on the
Right.
Bible and,
Right.
you're in a court. So, but anyway, I appreciate everyone for sticking with us. This is a little longer than we normally do. We will
Right.
have an update.
So make
Subscribe.
sure,
Yeah, go
like
ahead.
and subscribe
Like and subscribe, baby.
and leave a
And
comment.
leave a comment. And if you're Broadcom's attorney, get on the show, man. We're nice
Right.
people.
Because it's not looking good right now, Broadcom. I think you better come on.
All right, Ed, thank you. And thank
Thank
you
you,
all for
Craig.
joining the world's greatest podcast.